All right, go ahead and call the case.
Good morning, Your Honor. We are here in the matter of the State of Oregon versus Alan Swinney. This is court number 20 CR 50067. Nathan Vasquez representing the District Attorney's Office in the State of Oregon. For the record, my bar number is 014437. Also present here on behalf of the District Attorney's Office in the State of Oregon is Mr. Reed Schweitzer and Mr. Adam Gibbs for the purpose of motions only today. Your Honor, this is the time, date, and place for motions in this matter. Mr. Swinney is present. He is in custody. He's represented by Mr. Joe Westover and Ms. Megan Desai. Your Honor, the state is prepared to proceed. I would request that the court remind the parties, because it has been an issue, and I apologize, not the parties, but those present in the courtroom. This has been an issue in past hearings that there is no video recording allowed inside the courtroom without the court's permission.
All right, thank you. And go ahead, Mr. Westover.
Good morning, Your Honor. My name is Joseph Westover, W-E-S-T-O-V-E-R, bar number 141275. We're here for the motions. Ms. Desai is helping.
And good morning, Your Honor. Maggie Desai, DESCI, bar number 141441.
All right, thank you. Good morning, everybody. So I guess as a preliminary matter before we get into the motions, I did want to touch base a little bit about some of the behind-the-scenes planning that is going on with regards to trial next week. But it's also a great segue into what Mr. Vasquez just mentioned, and that is that without the court's permission, there is not to be any recording today in the courtroom, and I have not been asked for permission, nor have I given permission for any recording of today's proceedings. For the trial itself, the decision has been made that the trial will occur in courtroom 11A. That is a slightly larger courtroom. It's going to allow our jurors to be more safely socially distanced. I will reserve the back rows of the courtroom 11A for colleagues and investigators of either side. Otherwise, the courtroom itself is going to be closed to the public. This is an unrelated book and keep, so no one needs to worry about this. So otherwise, 11A is going to be closed to the public. This courtroom, courtroom 8B, will be available and open to supporters of Mr. Swinney's. And then courtroom 10C will be open to the victims, the alleged victims, rather, and any supporters of the alleged victims. We will also do a Webex stream of this trial, unless either party has a strong objection to that. I feel like there is significant interest in this case. This is a way for us to potentially limit the people coming and going from the courtrooms. I know there are a lot of individuals with blogs, podcasts, and other media that are interested in recording the trial. I will allow either cell phone recordings in the observation courtrooms or obviously recording of the Webex live stream because I believe that I can protect the juror's identity. Does that work for the parties?
Yeah, I think you hit what my concern at the end there. You said I would ask that jurors remain anonymous during this trial. That will be the law starting next year.
Yes, and we're going to do that. We're going to. So thanks for bringing that up. I've instructed Mr. Keenan to speak with Ms. Mayall, Judge Lucero's clerk. They have already begun instituting a numbers system for jurors. And it would be my intention that we use the number system for jurors in this trial. So we will not refer to jurors by name, but by number. And that will help protect their anonymity.
Will we also keep them off of the web stream?
Yes.
Okay.
Yeah, absolutely. We'll keep them off of the web stream. And even if that, I mean, I just, to the extent that we even have to shift over a little bit, I've been in 11A before, but I'm having a difficult time visualizing kind of the different way the gallery looks, but we'll figure it out so that Mr. Keenan obviously has control over how the Webex cameras capture images in the courtroom, and they will not go back into the gallery at any time.
And if we need to do some sort of planning about, for the purpose of the attorneys, if we decide we want to get up and mosey around, if there are spots that we can't stand without having the camera on us and showing the jury, maybe we can figure out those areas before trial. So
for sure.
Go there.
That's a great point. I don't see a need to live stream jury selection.
Agreed.
So I will not live stream jury selection, and obviously I'm closing the courtroom to the public for jury selection as well. So the courtroom, the observation courtrooms will be open during jury selection if people are looking for a place to congregate and want to be present once the trial starts. I don't know. I mean, I can't imagine we're going to get to the merits of the case on Monday. So to the extent that people can let their stakeholders know. Yes.
Yeah, and that was a question for the state. As far as the jury and all the discussion there, the state's fine with all of what the court is proposing.
Okay.
Has no issues there at all. I just want to be able to give witnesses. I know some of the officers had expressed that they had been subpoenaed by the defense and that it was for Monday morning, and I wanted to be able to let them know that the court, and I can't speak for the defense, but when they should appear.
I do subpoena officers when I think that it's necessary. When my experience so far, I've made efforts to contact one detective in this case, and the response was talk to Mr. Vasquez.
Okay.
So I don't anticipate really it being. I generally assume that cops are not going to talk to me. They're under subpoena for Monday. If they want to reach out to me and say, hey, do you need me on Monday? I'm happy to say no, but their subpoena's for Monday.
So it sounds like they need to work with Mr. Well, okay. We're not going to get to them on Monday, right?
No.
So.
I mean, they're my witnesses and the state goes first, so.
Right. So I would like to carry the subpoenas till at least Tuesday at noon. I understand
They're not
what
here.
you're saying, but I mean, you don't need to be shagging a bunch of phone calls in the middle of this trial either, Mr. West.
Well, I don't like talking to police either.
So I think I'm going to carry the subpoenas until at least noon on Tuesday, and we can kind of look at the trial schedule. Do the parties want to just agree right now that all we will do on Monday is jury selection, and then we'll start openings Tuesday morning, assuming we've got a jury by Tuesday morning?
I'm okay with that.
And then your witnesses,
Yes.
you don't have to have witnesses sitting in the hallway on Monday or sitting in observation courtrooms, etc. Okay.
Your Honor, sorry,
Yes.
what
No,
was
that's okay.
the courtroom for observation for defense?
This very courtroom, 8B.
Thank you.
And then, and like I said, then, so I will also say this. Every morning I'm going to visit the two observation courtrooms before I come to 11A to remind observers of the decorum that the court expects, even though they're in an observation courtroom. Each courtroom is going to not just have a clerk, but they will have deputies in the courtrooms. And if people are unable to behave appropriately, they will be removed from even the observation courtrooms. I'm not gonna mess around with that at all. And so the deputies have my permission to remove whoever they believe they need to remove so that the courthouse can operate safely, up to and including trespassing somebody from the courthouse for the pendency of the trial if we need to do that. And that's frankly, for several reasons. I did, it's not funny, but it's interesting that my last trial before the pandemic was a protest trial of a very different sort from this. But what I do remember was the courtroom, of course, before social distancing, was packed with observers, and the jurors and those observers were well behaved and calm observers the entire time, but the jurors still noted their presence very much. I feel for both the state and the defense to have a fair trial in this, it's going to be really important that the jurors don't see or feel any sort of pressure from external interests. So any other thoughts, ideas, etc. about kind of...
Can we have a brief sidebar about that I just sort of want to stress this?
Do you want to go in the hallway?
Sure.
Okay.
Yes,
You stay here.
You can go back on the record. All right, are we ready to get to the actual merits of these motions?
Yes, Your Honor.
Okay. Well, it seems to me that the motion to dismiss makes the most sense to go first, because if I grant that, then everything else is moot, right?
Yes, Your Honor.
Okay. So, Mr. Westover, your motion to dismiss for improper evidence presented to grand jury.
Sure.
The floor is yours.
And I know that I believe both my motion and the response were sent to you and that you had an opportunity to read them.
I did.
I'm just then going to make a few notes then on that I think that I came up with in addition last night when I was preparing, so we're not rehashing the actual motion. And then I'll just make myself available for any questions.
Okay.
I do have as well, and I've already given a copy of this to Mr. Gibbs. He's indicated that he is familiar with it. I am going to reference it at a certain point during my argument, but last week the Oregon Supreme Court granted an alternative writ of mandamus. Judge Lopez had denied a defense attorney's motion to be present with their client at grand jury when the client was testifying, and the Supreme Court said you gotta let him in. So I'll present a copy of it. It's just for the court's reference. It's the granting of the writ and then the actual trial motion as well.
Okay.
So, I mean, I guess the hyperbolistic opening sentence that I'll give in terms of this motion is, you know, we all know that grand jury, in the sense that it is looking to find something similar to probable cause, is a low bar, but we can't allow it to become a joke. And the statute that talks about what evidence is available at grand jury provides broader protection to somebody who's being alleged to have committed a felony than does the evidence code itself. It does not say that the evidence code applies here. It says that no evidence shall be given at the grand jury that would not also be admissible at trial. So, for example, right, hearsay might keep something out at trial, but also confrontation might keep something out. There might be other things that would not be admissible at trial regardless of the evidence code. So it's the circumstances that really determine what can be given to the grand jury. And what we're talking about here isn't necessarily that the evidence that our other motions do deal with the fact that this other evidence should not have been given at all. But to the extent, if Your Honor considers that it is appropriate for there to be a limiting instruction at trial, particularly from the 15th and the 22nd, then that limiting instruction needs to be given at grand jury as well. I'll concede that this is not a motion to dismiss. It's basically I'm tattling on the district attorney for doing something that I think that they shouldn't have and asking you to exercise your discretion under the statute authorizing you to dismiss a case in the interests of justice. And I just lost my train of thought.
It's all right. Take a moment. We've got time.
So that's what I'm asking for you to do, is to dismiss the case in the interest of justice. And I guess I'll just respond to a few things that I see in the state's response. Is one of the things the state argues is this holding in State v. Stout, which both Stout and McDonald, cases that were cited by both parties in their motions, were addressing a particular statute that just talked about the circumstances under which an indictment can be set aside. And the state presents an argument basically that says that there's no other statutory authority to dismiss an indictment. And that's just not correct. For example, Your Honor has the authority to dismiss a case in the interest of justice, as does the district attorney. And if it was true then that an indictment, that no other statute authorizes an indictment, then all of a sudden your power to dismiss in the interest of justice and the district attorney's power to dismiss in the interest of justice is limited to misdemeanor-only cases, unless that misdemeanor was presented to a grand jury in which it returned on an indictment. It is not, would not be authorized, you would not be authorized to dismiss an indictment that went to grand jury, but if somebody waived indictment and allowed to proceed on information, then you would not be able to dismiss in the interest of justice. Let's see. If a case were to go to grand jury with recommendations for a felony or a misdemeanor and the grand jury not true billed the felony but indicted on the misdemeanors, you would not have, you would have the authority, you would not have the authority to dismiss that case in the interest of justice. And this district attorney's office does make it a policy to, even when there are only bias crimes alleged, they're taking those to, bias in the second degree alleged, they're taking those to grand jury as well. So the argument that there's no statutory authority existent to authorize Your Honor to do that is just incorrect. I'll also point to ORS 136.120 subsection 2. When the state comes to trial and reports not ready, then the court shall dismiss the case. And that statute, subsection 2 of that statute, talks about dismissing felonies. So there is an ability for the court to do this. I think that the situation in Stout and McDonald is they didn't contemplate this situation. This was at a time, those cases were decided at a time where I don't think grand juries were public anywhere. Since then, the legislature of the state of Oregon has decided to bring grand juries into the light, sort of. They are to be recorded, they are to be provided to defense, and some of the things that we've noticed, the reason that grand juries have been private and secret for so long is because there was this presumption that prosecutors were following the law and doing the right thing. Very soon after or around the time that this grand jury bill passed, we started, it was sort of incidental. An attorney from my office, in fact, was waiting outside grand jury, was told that it was a not true bill, and then the state presented a cannot proceed instead of a not true bill, which is apparently they had been doing for quite some time. They weren't following the law. We're seeing now as well that, you know, I see district attorneys sometimes haphazardly make a, well, don't consider that, that's hearsay at grand jury. So they know that they need to do this. It's in their handbook, which is cited to in my motion. And the court needs to hold them accountable. When it comes to a circumstance, I guess the circumstance of the writ of mandamus that I provided to you, there is solid evidence right there that the Oregon Supreme Court considers somebody's constitutional rights important. Because when a person testifies at grand jury, they're going to be cross-examined by the district attorney. Their right needs to be protected. And it's the same case when we're talking about the presentation of other acts of evidence. When there's nobody there to say, hey, wait a minute, the law says that you cannot present this information in this form. While it may be admissible, you need to caution the jury what it can and cannot be used for. This is where the court needs to step in. This is a circumstance that's even different than that circumstance in Gray, which is Mr. Swinney, because this was a secret indictment, he didn't even really have an opportunity. He didn't have a statutory right to go testify at that grand jury. So he couldn't have even requested that a lawyer be present anyway. So it's a circumstance where there's two gatekeepers here to guard against, to protect the constitutional rights of a person who's alleged to have committed crimes. First stage, it is the district attorney. When they do not judiciously guard against that, then it's up to the court to step in and say, try again. You got to do it right. I don't think that's that big of an ask, quite frankly, to ask them to follow the law. To respond also to, this goes back to sort of my first point about conceding this is not a motion to dismiss. It's a hey, don't let them do that. argument is that the state, I'm not saying that it is due process that requires a dismissal in this case. I am saying that the practice of, and if it's unclear in my motion, then I apologize, and that's why I do want to clarify. It implicates due process when we're having these 404.4, quite frankly, and 404.3 and 403 evidence coming in at grand jury without any sort of deliberative, should I or shouldn't I, and what do I actually need to tell the jury about how to use this. That is something that we'll get to in one of the other motions, that the district attorneys generally like to come in and have been successful in the past at saying intent, motive, plan, and just saying those words, those buzzwords from 404.3, the second sentence. Skillicorn tells us that no, there actually needs to be, you can't just say it's this prong. You need to say this is the fact that we are proving, and this is the inference that we're asking to take from that fact, and all of the line of inferences down to the ultimate point, and if any time along that way you end up with propensity, then that's just not admissible. That's something that's completely separate from the overruling of Johns. That's completely separate. It is what other acts of evidence is. And it is prejudicial too. I mean, we're seeing cases reversed all the time where judges are getting it wrong, and quite frankly, in many cases, it's because the district attorneys are not coming with the actual theory of how this evidence is relevant and what facts they're proving and what inferences they're asking to be made. They're just coming in and saying intent, plan, motive. Skillicorn says judges make them articulate their actual reasoning with regard to relevance. I'm not even saying that they have to be perfect at grand jury, but they can't just ignore their obligation. In response to the argument from the response saying that there's no statutory authority to, let's see, the 8th Circuit case they cite to talks about there's no obligation for the prosecutor to provide instructions. ORS 132.340 says that the district attorney must attend the grand jury sittings and advise it in relation to its duties. There's statutory requirement that the district attorney, as the gatekeeper of who gets to charge people with felonies in this state, is obligated to instruct the jury as to its duties. And if one of its duties is to, just like a regular jury, fairly and without bias and without relying on propensity evidence to make a decision, that is the obligation of the district attorney in this case. With regard to, this is back to McDonald and Stout, those cases are talking about evidentiary irregularities. This is not a case about an evidentiary irregularity. It is a case where the district attorney presented evidence of 2 separate days, 2 completely separate criminal episodes, and did not caution the jury at all. And with response to, and to respond to the state's argument that, oh, you don't get to use the grand jury transcriptions or recordings as evidence in a subsequent hearing, well, my first response to that is, really? I can't use it? Let's imagine a more drastic situation where the district attorney goes in and is recorded saying, you, the members of the grand jury, you've heard the evidence, you have to indict this person. I can't use that? This is slightly less than that, but it really, with regard to, I don't want to say misconduct, but with regard to, discarding its duties, it's the same. the state cannot tell the jury what to do, just to the same way that the court can't tell the jury what to do. The jury makes up their decision. So I would say, first of all, that statute that says you can't use it, it fails as applied to these circumstances under the Constitution due process particularly. But if you don't find that, then you don't need to. The indictment is clear. We've got 5 counts alleged to have occurred on August 15th, and we've got 7 counts alleged to have occurred on August 22nd, 2020. And all you need to do is ask Mr. Vasquez, without reference to the transcript at all, is, did you caution them? The answer is no. I believe that's all I have, Judge, and if you have any questions, I'm happy to try and answer them.
I don't yet. I'll let Mr. Gibbs or Mr. Vasquez go next.
Thank you, Your Honor. This is Adam Gibbs for the DA's office. I'm going to be addressing this motion. I hear from defense's argument a policy argument. My response, I know the court's had a chance to review it, is focused on rights and remedies. What is in the statute? With respect to 132270 sub 7, which is the prohibition on using recordings, I get the counsel doesn't like the statute. The statute's plain, right? And the court and the legislature, in enacting that statute, was attempting to limit the cost of the recordation bill by prohibiting exactly the hearing we're having right now, because it's not supposed to be challenged based on that. I will also say that the recordation statute requires only testimony to be recorded. It doesn't even require any legal discussion or advice to be recorded. So there's no evidence as to what the grand jury was or was not instructed. And I'm somewhat dumbstruck by counsel's request that the court interrogate opposing counsel, interrogate a lawyer about what he advised or did not advise a person he has a duty to give legal advice to. I honestly don't have a response to that. Moving back, defense has walked back from saying this is a motion to dismiss, despite it being captioned a motion to dismiss. Again, this shouldn't be in front of the court at all, because the sole statutory authority that they're citing for a dismissal rests in the court sua sponte, and this is not sua sponte. You can't move the court to do something and then say, Judge, I'm moving you to do something on your own. That does not work in the way our system works. With respect to statutory bases to dismiss, what Stout, McDonald, Dyke are talking about is challenges to an indictment, not the procedural and ministerial dismissals that happen on a daily basis in this courtroom. This courthouse. Dismissals pursuant to plea, dismissals interest of justice, dismissals for speedy trial, you name it. Dismissals happen all the time. Of course dismissals can happen. What this line of cases is talking about is challenges to an indictment based in statute. This is a challenge to an indictment based in statute. And there is a dearth of authority in Oregon around this area simply because there's no basis to make these challenges under the law, so we don't have authority. To the extent defense is citing to federal constitutional grounds to undergird the dismissal, and as I said, counsel walked back a little bit from due process generally. This is, I guess, due process light that we're talking about here. That's the sole basis the court should be considering the federal opinions I've cited. I get the federal feds have very different criminal procedural rules, statutory authority under which their grand jury operates, and I don't even begin to pretend to represent to the court what those are. I don't know. I don't practice federal criminal law. What I do know is that because Oregon's Constitution lacks a due process clause, anything about due process we're talking about is federal. It's under the federal Constitution, under our court's interpretation, under the United States Appellate Court's interpretation. And while, of course, this court is not bound by a federal court of appeals interpretation of the due process clause, it's certainly persuasive. This court is, of course, bound by the United States Supreme Court's interpretation of the due process clause. And every court that I found in the federal system that was interpreting this found there is no constitutional irregularity under the Fifth Amendment, under any amendment they were talking about, to have legal instructions given to a grand jury at all, or even to have evidence competent at trial given to a grand jury. The examples that were given in some of these are literal Miranda violations, coerced confessions was not a constitutional violation to give to grand jury. Of course, in Oregon, that would be a flagrant statutory violation, but it's not a constitutional violation. And McDonald, Stout, and Dyke locally say you can't make a statutory challenge based on incompetent evidence being presented to the grand jury. I mean, Dyke, I led my summary with a specific quote from Dyke that an indictment cannot be set aside because a grand jury considered evidence that might not be admissible at trial. I hesitated somewhat for leading for that because our position is this is not saying, Judge, we made a mistake, we did something wrong, but you don't have a remedy, so too bad. The evidence we believe was properly admitted, but even assuming it wasn't, there's no basis to move against the indictment because improper evidence was presented to grand jury. And it's frankly that simple. I want to emphasize this is not us playing fast and loose and then saying, but there's no remedy, so too bad. I outlined the somewhat unique legal posture here, and while I know that the other act's evidence is to be subject of more detailed litigation later today, the legal framework of other act's evidence changed dramatically between grand jury and now in Oregon. State v. Johns, which has been a bedrock of other act's evidence for over 3 decades, was overruled by Skillicorn, as counsel pointed out. Now, for all the reasons that I think Mr. Vasquez will talk about later, we think a lot of this evidence is admissible under Skillicorn. But it doesn't matter. There is no requirement that grand jury be instructed. I think the Ninth Circuit referred to in, I think Kenny here that I cited, talked about the parade of horribles if instructions were required at grand jury. And I think refers to it as exactly this kind of hearing as the toilsome mire of exploring whether or not these instructions given were precisely right. Due process gives defense the opportunity to challenge all the evidence, to litigate all the instructions, and have that decided at a trial jury. And we have a very thorough system for vetting that, getting those instructions, dealing with that. Looking back in time and saying we shouldn't even get there because here are all the instructions I thought should have been given. Instructions are often hotly litigated, disputed. This system was not set up to allow 2 bites at that challenge, to dismiss prior to discussing about instructions because of a dispute. So, in summary, 1, there's no basis to determine what instructions were or were not given to the grand jury. Frankly, I would be very surprised if the type of instruction counsel thinks should have been given was given. It's simply not the practice generally to give detailed legal instructions. But there is no record in this case as to what was or was not given. 1, because they can't use the recording, and 2, because even if they could, the recording almost certainly wouldn't have that because legal instructions aren't required to be recorded. And in any event, it was lawful, and we can talk more about limiting instructions when we get to the instructions downstream. With respect, very briefly, to the mandamus petition that counsel raised, I really fail to see the relevance of that. Of course, the Oregon Supreme Court thinks constitutional rights are important. This was a Sixth Amendment issue about right to counsel. It has absolutely nothing to do with evidentiary issues in grand jury, and in any event, from my conversation with Tort and Justice, this is still under active litigation. But that issue I don't think is really relevant at all to what we're talking about here.
Okay, thank you. Mr. Westover,
I
final
just have
words
a
to
few
you.
responses, and I mean, regarding one of the last things that Mr. Gibbs said, no, sorry, this is regarding one of the first things he said. He said
Okay.
Mr. Westover is making a policy argument. I disagree, but what is evident is if the district attorney thinks, and if there is some circumstance that there will be, what did he say, toilsome mire, then they can completely avoid that issue, and it's their policy not to. They have every single right under the state of Oregon, the statutory law of the state of Oregon, to take August 15th to grand jury and see if that grand jury indicts, without any reference whatsoever to August 22nd. And then they go and they take August 22nd to a grand jury and see if that grand jury indicts, and then they can move to consolidate those cases. There are statutes that allow to do that. That completely eliminates the issue, but they just want to get it done. They choose not to do that, and that is on them. If they're concerned about people making these types of challenges, they can completely avoid it, and then we just fight about whether consolidation should happen, or they can pay attention, and as the only attorneys that are currently allowed in a grand jury, they can do what it sounded like counsel was acknowledging is they do have an obligation under Oregon law to advise the grand jury. They can scrupulously guard against against the person's rights at that grand jury hearing. He also mentioned that it's his understanding the legislative intent of the statute, ORS 132.270 subsection 7, was prohibit the cost of litigation. Last time I checked, that seems to be a very low priority when it comes to safeguarding the rights of the people of the state of Oregon and anybody who comes here. Regarding his reference to federal law, he completely ignored all of the cases, or many of the cases that I cited, Bauman, Williams. These are all cases that talk about other acts evidence as implicating due process. He wants to just completely distract the court and say, look over here, look at all these federal courts that have said due process doesn't require dismissal. But Bauman and Williams, as the two sort of, at this point, touchstone cases, the beginning of this other acts revolution, those cases very clearly say, particularly Bauman, with reference to turnage, says that when propensity evidence is offered, more serious due process implications exist, and we need to make sure that we safeguard against that. And what I guess I didn't say before is there is the reason that propensity evidence is so important to get right is because of just how damaging it is to somebody. This notion that this other crime, wrong, or act that this person is accused of doing creates essentially a presumption that those finders of fact will use that against the person with regard to the second act. It is, there are federal cases, and I can't remember them, where they tell it's not a matter of relevance, it's not a matter of how relevant, it's a matter that it's too relevant. That people will think because you've been accused of doing something bad before, you're just going to do it again. And the phrase from Williams that I am very fond of is it creates in Oregon this idea that we should really, really pay attention to of this, they call it cognizable probative value. There's really no difference between probative value and relevance. Relevance is something that has probative value. Something that does not have probative value is not relevant. So what they're talking about is cognizable relevance. To what degree should the law recognize this evidence as valuable? And in those circumstances where the obvious inference is not something that the law acknowledges, you just cannot allow it in that form. And that's the problem. We're not talking about, and it is just the district attorneys in this case just completely shirking their obligation to advise the grand jury of how it can and cannot use that evidence.
All right, thank you both for your arguments and for the written motions on this. I think certainly the body of case law surrounding the dismissal of a grand jury indictment stands generally and strongly for the notion that the grand jury process should be afforded great deference. With regard to the due process issue and how that is or is not implicated, I think, I am persuaded that the change of the law, the law of Oregon from Johns to Skillicorn is relevant here. Although I would say even operating under the Skillicorn rules, I'm not sure I agree that the presentation of evidence as is presumed to have happened based on looking at the indictment and your review of the recording. I have not reviewed the recording. I don't know that I believe even still that what the state did was inappropriate. So knowing there's no real statutory basis within Chapter 132 for me to dismiss an indictment based on this information, knowing that there's no case or constitutional reason, I am, then left to address this question of, do I believe in the interest of justice a dismissal of this indictment is appropriate for the reasons that you outlined, Mr. Westover? Do I think that the presentation of the two separate incidents to the grand jury, potentially without instruction to the grand jury, is so egregious that in the interest of justice, I need to dismiss this case? And I simply do not. I don't believe that what the state did rises to the level that I should, of my own motion, dismiss the indictment. Again, I think both the change in the law is relevant here, but I also just think I do have questions about whether I would even have the authority to do it kind of the way it's being presented to me here today, because I am getting stuck a bit on this notion that the grand jury transcript should not be the basis for a motion to dismiss. I frankly agree, Mr. Westover, that if the grand jury transcript presented some egregious, as you used in your example, a district attorney being recorded to the grand jury saying, listen, this is just a bad guy, just indict it and we'll worry about it later, something like that, then maybe I would think that, some sort of constitutional remedy should come to bear and overrule the legislative limitation on how grand jury recordation can be used. I don't believe we have that here. I don't believe that what happened at grand jury was inappropriate to the level that it needs to be dismissed in the interest of justice. So that is my ruling on that. Now we have the motion for election, I think is what we should move on to now.
Yes, Your Honor. It certainly is the defense's motion. I'm not meaning to steal their thunder in any way. But the state is, in looking at this, prepared to make election on certain counts that may help narrow the argument.
Okay. Well, and so here's what I was going to say to both parties, frankly. I read the filings. I feel like to a certain extent, some of this argument presumes I have some knowledge about this case, and I want to make it clear I don't have a lot of knowledge about this case. So, and I think this is going to come up again when we start talking about prior/other bad acts evidence. There was no affidavit of probable cause. It was a secret indictment, so I can tell from the indictment, and obviously I don't live under a rock. I've read the headlines through the last year and a half of protests generally. My knowledge of Mr. Swinney and what he has or has not done at protests is nil. I mean, beyond the indictment. So, I didn't seek out any YouTube videos of the protests to see what I could see. I didn't do any of that because I wanted to be, a fresh trier of fact or, trier of motions for this case. So, having said that, to say simply the state needs to elect, I don't entirely know. So from my perspective, it would be very helpful to sort of go count by count on the counts in question. I did print out a copy of the indictment so that we could do this. And so let's just, yes.
Sorry, do you think it would be helpful to Your Honor making your decision if we were to just give you sort of a brief overview of what we think the evidence will show at trial? Essentially, I could do it in 2 to 3 sentences.
Okay, sure. 2 to 3 sentences.
Okay, so 2 incident dates, both involved a demonstration that had a counter protest come to it. There is a period of time in which these allegations occur over each day, and some of them have named witnesses and some of them do not. But within that period of time, there needs to be some identifiable victim in act.
So, and that certainly was, I got the gist of that. I guess, so, let's just say, for example, unlawful use of mace in the second degree. I don't know if there's video of Mr. Swinney spraying an entire crowd of people with mace, and you're going to say, we don't need to say there's one single person. I mean, right? Like that's why I think really, truly, we need to be very methodical about this and go count by count. So I guess what I'd like to do first is just to the extent the state is prepared to make some election or give you some more quote unquote definite and certain information about how they intend to prove each count, let's do that first. And then to the extent that additional counts still remain that you are wanting more information, we'll explore that again on a count by count basis. So Mr. Vasquez, with regards to count 1, attempted assault in the 4th degree, on August 15th, 2020, what is the state's thoughts?
In your, I prepared for the ones that were in defense's motion, not to do every one, because I think some of them were not in defense's motion.
Okay.
So for counts 1 and 2, those would be for essentially the same victim.
Okay.
And it would be for witnesses and evidence will show the female was sprayed in the face with mace on 4th Avenue. And it would be on the date alleged.
Okay.
And for context to the court, there was an initial rally, demonstration, whatever you want to call it, in front of the Justice Center. And then the parties, both sides, counter-protest and the protest, or demonstrators, counter-demonstrators, then proceeded to kind of move through the city, through a short, brief kind of walk through the city. They stop along 4th Avenue, and that is where this occurs.
Okay. Do you know by him saying a female on 4th Avenue who he is referring to, or is there clothing? I mean, I know it gets a little muddled because as I understand it, like there's a lot of similar, uniform's not the right word, but similar clothing choice.
I believe in the discovery there was a single female that was sprayed directly in the face.
If what would be very, very helpful is if we're just talking about the Jason Britton video, if you could give me a timestamp. Or whatever video and a timestamp.
I can try. I don't have that off the top of my head.
Okay.
What I know is this. This is what I know. As it moves, there's only like a brief section where they're in the middle of the march and they are on 4th Avenue. And then they stop. There is a back and forth discussion. During that time, the state alleges that Mr. Swinney first sprayed a woman in the face, in the face with the mace. And then immediately after, he pulls up his paintball gun, or not immediately, but shortly thereafter, he pulls up his paintball gun and then shoots a person in the face with a paintball. It hits him in the forehead.
Okay. Is it worth the time right now to pull the video up and to find the moment in the video that you're referring to with regards to the mace?
Yes, and so, if I may briefly answer the court's question. So, as long as it's not, hey, that was shown right, that's the only evidence that can go to prove that. I'm fine trying to identify or help identify what we're talking about.
So I think, right, this is where, frankly, the next 3 motions really start to have some overlap, right? So I think that is whether or not I'm going to let other stuff come in under kind of the other bad acts.
I think this would probably all be not other bad acts. This is all just stuff that would be direct evidence of.
Sure. Yes. I mean, to the extent that the defense is at some point, I suspect, going to argue, okay, that's the 3 seconds that mace gets sprayed in this woman's face, and that's the only 3 seconds of that part of the video that can be shown. I think that's based on an other bad acts argument, right?
I'm not even sure I'm gonna make that motion.
All right.
All
right.
So I'll let the court know if I decide to make that motion.
All right. Okay. Perhaps my tone has already given away what I might think of that, but in any event, let's pull up the video. Let's show the moment. I'm not, by having the moment be shown, pre-ruling that is the only evidence that can be shown, but rather this is giving the defense the ability to see how counts 1 and 2, how the state intends to prove counts 1 and 2.
With the caveat that there is massive amounts of video in here, so it may take me a little time to do that. So I apologize. I will try to get to it as quickly as I can.
We have still 90 minutes today, this morning, and then another 90 minutes this afternoon.
An example that may be easier if we want to jump to
Sure.
is counts 9 and 10.
Well, okay, wait, before we jump, let's go count by count, and then we can find the video, or maybe Mr. Schweitzer's kind of trying to do that while you and I talk. So count 3, attempted assault in the second degree. Is this the next person that you mentioned that gets shot in the head by the paintball, or is that something else?
Count 3 is attempted assault in the second degree, and that is the individual that is shot in the head with the paintball, and in nearly the same location. In other words, it's all same in the right area. I don't want to say exact, 'cause I'm not trying to be pinned into like where their feet in the same exact spot, but they stop mid-block on 4th Avenue, and that is where it occurs.
Can you tell if that unnamed victim is a male or a female based on the...
He appears to be male.
Okay. So we'll find that video as well. Count 4, unlawful use of a weapon.
This one, because of the way that it is pled, is it carries with the intent to possess or use unlawfully against another a paintball gun. I do not believe the state needs to elect, because that would encompass all of the activity on the 15th, during which time he was carrying the paintball unlawfully with the intent to use it.
Okay, we will address that potentially later if the defense wishes to address that. Count 5, assault in the second degree, has a named victim. You're comfortable proceeding on that?
I believe, so long as I can confirm, it's when Jason Britton gets shot in the eye.
Yes.
There we go.
All right, and then count 6, Megan Stewart is named, so I'm assuming we're clear on that.
We're good there. That's the video that, I assume you're going to try and prove that with the video that Ms. Stewart took.
And her testimony.
And the picture of her. Right, okay.
Okay. Count 7, unlawful use of a weapon. Now, I guess count 6 is where we move on to, sorry, the next day. Count 7, unlawful use of a weapon. I assume the state's argument is the same for count 7 as it is for count 4, that you should not be required to elect.
Yes.
Okay. Count 8, unlawful use of a weapon with a firearm. Same argument?
Yes.
Okay. Count 9, menacing.
Menacing and count 10, these are both the same. I would say they're maybe, I don't know, alternative counts, but they encompass the same activity. It is the one in which Mr. Swinney is on video, and on there's photographs of him with his hand extended with a revolver in his hand, pointing it on August the 22nd in the middle of 2nd Avenue.
I've seen that video.
And so are you comfortable with that information moving forward?
Yeah.
Okay.
I think everybody in Portland has seen that video.
I don't know that I have. Honest to God. I don't know. I guess our DirecTV went out at the start of the pandemic and we never got it fixed. So my local news access has been severely limited. All right.
That was counts 9 and 10, correct, Mr. Bassett?
Yes.
Okay.
Yes, it was.
All right. Count 11, unlawful use of mace in the second degree, and assault in the 4th degree. Count 12 are both Megan Stewart, who is also the named victim in count 6. Is that... Ooh. Sorry, I just did something.
I believe her grand jury testimony, and also it may be in the police reports, she talks about it.
Okay.
I understand and I just want to make sure that the assault in the 4th degree, that is not getting shot with a paintball, it is getting hit with the mace.
That is correct.
Okay.
So count 12 is not a lesser of count 6, it's a in tandem with count 11, essentially.
Yes.
Okay. So then the unlawful use of a weapon charges. Now I have to go back and look at your motion for election. So you are still, Mr. Westover, arguing that counts 4, 7, and 8 require further information?
Let's see, for
Just the 3 UWs.
Yeah. There's nothing, no cases that I'm aware of to support the state's position that they don't have to actually identify the person against whom the weapon was intended to be used, unless they're willing to concede that he was only intending to use it against people that were that he perceived were committing or attempting to commit acts of violence against him. I'm fine with that concession.
I'm sure that that's not a concession the state's going to be making this morning.
That is correct.
And I think they rely. It's interesting that they do elect on menacing. Their motion says they don't have to. I agree. Both Payne is. Oh, I almost made a pun there. I'm not going to. Payne has 7 pages of dicta, and then says, "Oh, by the way, this motion was properly because of this case, State v. White." And State v. White does talk about how multiple acts can constitute menacing, but in that case, you still had an identified person against whom the menacing was committed. In that case, it was a series of events between a man and a woman in a car. We just want to know against whom. Everybody? He was there to use it against everybody? I mean, that seems absurd.
Your Honor, if I may ask, could we potentially turn the Webex on so some of our colleagues could listen in on pre-trial motions?
What is the state's position on streaming this argument?
I don't have any issues with that, Your
All
Honor.
right, we can turn the Webex on.
Thank you.
Now, I have heard from other colleagues that sometimes what ends up happening is then there's a lot of email or texting about make this argument, make that argument. So if I feel like it's starting to really gum up the works, I am probably gonna get spicy. Okay.
No,
All right.
Just from a pure learning.
All right, that's fine. Okay, so
Your Honor, may we respond on the menacing piece?
well, yeah, but you elected on the menacing.
Yeah, but
Yeah.
So I didn't know why we were going back talking about it.
The reason that we're not talking about it is because their support for why they don't have to elect for the unlawful use of a weapon is based on State v. White, State v. Payne, which says that you don't have to elect a single act in order to properly allege menacing. But it says nothing about unlawful use of a weapon.
All right, Mr. Vasquez, so go ahead and talk to me about the...
All right, so we're talking about the unlawful use of a weapon. Is that?
Yes, we are relying on, or we are specifically addressing at this point counts 4, 7, and 8, and whether or not further election/information needs to be provided to the defense at this juncture in the trial.
I would stand on our motion, which I think both the state, in looking at through this, I believe the case law and the statute support that we do not need to elect even up until the close of the state's evidence. But short of that, we have elected on certain counts to try to narrow the arguments. But in particular on the unlawful use of a weapon, the way this charge is written is that he is carrying it, which he is doing throughout the time he enters into this arena, if you will, of our downtown until he exits. And so for the state in particular, it's that time period.
It's also alleged as attempted to use, which attempt requires a substantial step towards, I guess, using unlawfully in this case. But
You know, they can plead in the alternative, I guess, but
because the statute says they can.
right, but
Yeah.
they still have to say what's the attempt to use, and if they say that there's no attempt to use, then let's just like interlineate and scratch that part out of the if they're not proceeding on that.
So again, this is one of those times where, right, I mean, you know, when I read through Payne last night, and that's Judge James's opinion. And he talks a lot about kind of, you know, he equates these types of sort of pre-trial motions for election to the Rule 21 motion to make more definite and certain. And, you know, and typically those motions to make more definite and certain then, you know, there's a whole discovery process that occurs after that fact in a civil case, right? I mean, I know we're talking about a very different thing here. I mean, you know, there's no shortage of discovery in this case. I am gathering from the comments of the parties. And so I do think that the way that the statute is written and the way that these charges are indicted, I am struggling with requiring further information at this time. But again, I don't know exactly what the discovery is. Do you know what I mean? Like, that's why it's a little bit hard in a vacuum for the court.
Sure. And could I tell you, try and summarize? I tried before and I didn't do a great job, but can I try?
Well, no, I mean, I understood what you're saying. It's just like, you know, I am persuaded that if the count as charged is that he carried this with the intent to use or attempt to use it against another person, I mean, I actually think that can arguably be any number of people at this stage of the game. Not that I am saying a trial is a game. I want to
No, I hear
clarify
you.
that.
You were speaking metaphorically, and
Yes.
I understood that. I'm just reminded of, and this, call it absurd if you will, but I'm reminded of the scene from the Steve Martin movie, The Jerk, where Steve Martin is this man, he moves to the city, and it's one of his happiest, earliest moments living in the city where he says, I'm in the phone book, I'm somebody. And then it cuts to this other random person that nobody knows from Sunday and is in the movie for 4 seconds, who opens the phone book, plops his finger down and goes, here's who I'm going to kill. Mm-hmm. It just seems a bit vague to be able to say that. It's similar to me in that. And I mean...
Now I'm just laughing thinking about the movie The Jerk. No, I'm not laughing at your argument.
I didn't think you were. But you could. It's maybe absurd.
Well, I mean, you know, I was actually kind of chuckling thinking I don't think that's the thing he's the most excited about when he moves to the big city, but
he's very excited about getting into the phone book.
Yes, he is. I remember that scene very well. Yeah. I having said that and having fond memories of that film, I am not particularly persuaded that it changes my mind right now. I'm happy to, I will concede, right? Like, kind of, your reply came in later yesterday, so I have not read every single case on this issue. I concede, in the context of this case. But I do think that the way it's pled, I don't think that the unlawful use of a weapon statute necessarily requires a specific person that an individual is carrying a firearm with the attempt to use it against them, or the paintball gun. I'm not articulating that very well, but that's my my ruling now. Now, it may well be that at the conclusion of the state's case, we discuss this again, that there may be instructions that we need to craft a certain way. I'm not saying that I'm not willing to revisit this issue. But today, right now, yes, go ahead.
Yeah, so revisit is sort of the point of, is what Payne cleared up. We don't, and like.
You're right. I'm not saying revisit this pre-trial motion to elect and make more definite and certain, but at a certain point, it is possible that there will be another motion from the defense that is a different motion that asks that the jury be instructed on concurrence in some way, and I'm not precluding you from making those arguments down the line.
Yeah. No, I know I can make those arguments.
Okay.
Thank you.
So that's my ruling on the motion to elect. Motion to sever?
And I'm sorry, you're.
Oh, we were going to show some videos.
Yeah, and
Yeah.
again, I believe there is more evidence of this, but here is evidence that I can present at this time to identify pretty clearly.
Okay.
I don't have a cable to connect with. If I have that, then I can put it up on the big screen.
Okay.
Sorry,
No, that's all right.
didn't anticipate that.
I understand.
And if they are ready, callers will not be able to hear the video.
That's fine.
That's fine.
I don't anticipate we need to play the sound. It will be more just the video.
Thank you, Phil, for letting me know.
And should I plug into laptop or monitor?
Monitor.
Monitor. Okay, just wanted to be clear.
All we're doing is trying to talk about what, like, they're not even conceiving of putting the gun in the face. I mean, they've said that the menace from the jury would be decided. It's not important. I agree. We're just trying to identify what he's talking about.
It had an effect, but I don't see it up there.
Yeah.
Let me see what happens if I hit the play button. Nope.
Well, this is as good a time as any to figure out our tech issues, right?
Although we're gonna get 11A, right?
Yeah, well.
Alright, I rechecked it. Let me see.
Set up as a second screen, not here.
I mean, you know the first thing I'm going to suggest is shut down, restart.
Let me try
The other option.
plug in the options here. There it is. It needs to be plugged into the laptop.
Okay, I apologize.
I'm gonna change it.
Okay.
Although now we're
Probably drag it over, read to the other monitor. You move your mouse over to the.
aha.
Yeah, that's tricky. Okay.
So smart.
It's going to give us a better opportunity to prepare.
This video captures the two individuals that I discussed in those counts.
So the individuals on counts 1, 2, and 3. Right?
1, 2, and 3. Yeah.
Counts 1 and 2 being the same person, count 3 being a different
Okay.
person.
This. Just going for a second.
Do you guys have VLC player? Because that's better.
Yeah.
I will try to open with VLC and we'll see if that does.
Windows Media.
That was my problem with all those videos that I couldn't get to play, is I didn't have VLC on the computer that I was trying to use it on.
That's been a frustrating part. Okay, so
Undershirt? That's fine. Yeah, we'll get that.
no, doesn't want to open it at all with that. Okay, that's awesome. I tried VLC, unfortunately for whatever reason it doesn't want to open it with that. No, that's the Windows Media. that play through here, and then I'll certainly enlarge it, but I don't want to mess with it right now. But in this video, you see there are two people. One is shot with a paintball gun, one is sprayed in the face with mace.
Wow, Mr. Swinney is so surrounded by people.
Not trying to litigate the case, I'm just explaining what the
If you expand it, we can at least see what
I know.
minute mark.
I certainly will. But this is the issue. For whatever reason, it doesn't want to do that up there.
I'm very familiar with this video, so I get it now.
There we go. Would you like me to play it one
So
more time?
you're satisfied, Mr. Westover, or you want to see it again?
Satisfied.
Okay.
Counts 1, 2, and 3.
All right. I'm sorry, Ms. Desai, did you have a question?
No.
Okay.
I do that.
All right. Counts 9 and 10, the video and photos revolver pointed at crowd. You said you know what that is. So you don't need to see the video/photos of that, right?
Correct.
And you feel you have enough certainty on counts 5, 6, 11, and 12.
Just 11 is right. Ms. Stewart in the park by the garbage can. Yeah.
Yeah. Yes.
That video? The one with the shooting guy in the face with the paintball gun? They're saying that is the attempted assault in the 4th degree. There's going to be a lot more about that.
All right. Anything else on the motion to elect?
I think we're good on that.
Okay. All right, let's do the motion to sever this morning as well, if everyone's ready to go on that.
I'm gonna just stand on my motion on that. I don't believe I have anything really to address except the state in its response did not respond to my 403 argument. So if Your Honor, I would ask Your Honor to engage in, if you're denying the motion to sever based on the either statutory or due process argument, then I would ask a 403 analysis to be done with regard to the two sets of evidence, and I can just explain it to you. You've seen a little bit. The video that you saw today is a situation where there had been the circumstances of the 2 days are quite different. There was in one day, Mr. Swinney was down with a group of people, and none of the charged offenses occurred until after Mr. Swinney had left or was trying to leave and was being doggedly pursued by a varying number of people, some of them bearing weapons, many of them vocally aggressive towards Mr. Swinney. The second day involves all of the alleged offenses occur at a demonstration that involved a number of groups, not just Mr. Swinney's group, that also had counter protesters who were, well, I'll just call them protesters because they were just there protesting what Mr. Swinney was doing, and they just throughout the day were just committing various acts of violence against not just Mr. Swinney and his group, but the other groups as well. So there are different the circumstances of the two sets of allegations are quite different, and quite frankly, there is the flashing of a gun. There's video of a gun being drawn, an actual firearm being drawn in the second case, and that's, I'm not sure if, maybe you remember my last trial with you, Judge, I asked an officer to pull his gun out during his testimony, and you just felt everybody in the room tighten when he pulled it out. A gun is a very powerful device, and there's no indication, there's no evidence that there was a gun on the 15th, but there is on the 17th, and what we're getting to, that right there is substantially prejudicious, that they're going to say this guy's got a gun. So I do think these need to be severed, and we're ready to go back to back. I mean, it's not like we wouldn't want to delay this any further. We can do August 15th, and then we'll just pick a new jury and go to August 22nd.
Okay, Mr. Vasquez.
I'm not going to say that I'm going to rest on my motion. I'll say that most everything is covered in my motion. With this balancing issue, there is not enough prejudicial components to this for any reason to sever. And with that, I'll leave it to the court for the severance.
Okay, well, to the extent that, I think we're going to start really getting into the meat of 403 and 404 in the next motion. But I believe, first of all, I want to just preliminarily say I have a lot of faith in trial juries and their ability to follow a court's instructions. I think they take their oath very seriously. I think they listen very carefully. I imagine we're going to be talking a lot about exactly what kind of language is going to go back to the jury. And I frankly have a tremendous amount of faith in their ability to separate the two incidents. I feel that the statutory scheme regarding severance motions is fairly clear, and that I think I have some discretion here. I feel that I disagree somewhat with the question about cross-admissibility. I think even if we did sever these, I think some evidence from each incident could come in, and for something other than propensity evidence. And so to the extent that any balancing act needs to occur here, and I may make some more statements on the record later today, but I again feel like the meat of this issue is really going to be in the bad acts evidence. I'm denying the motion to sever. I believe that limiting instructions will be sufficient to protect against confusion for the jury, or the jury inappropriately using evidence from each incident to prove, or finding evidence in one incident as relevant to the second incident. we can start other acts now. We're moving more quickly than I expected to, I'll be honest. Or we can break now and come back at 3:30.
I'm happy to see if we can finish up this morning.
Okay.
I have a number of motions in limine, and I'm as well that I don't know if you want me to talk to Mr. Vasquez about them first, but it's at this
I
point,
do want you
page
to
and a
confer
half.
with Mr. Vasquez first.
Yeah, I haven't, since I haven't heard about them,
I understand.
We can go. I'm fine.
All right. Then go.
Well, I mean, I'll just put it on Mr. Vasquez. He did exactly what I sort of referred to earlier by coming in and wagging his finger and saying intent, motive, rebut a defense. And what I need him to do for each and every single one of these exhibits that he proposes to admit, articulate the fact he's trying to prove, articulate the non-propensity theory that is relevant under the inferences that can be made, and I'll probably be saying that's a propensity inference, that's a propensity inference. So, him as the proponent of the evidence, I do believe that it is his obligation to get over the first hurdle about at least identifying a 404(3) theory of admissibility.
Okay. And I guess, right, this is again one of those things where, so your motion specifically says at least 4 of the witnesses the state has indicated it will call at trial were interviewed by police only as to the criminal conduct of another person who is charged in a separate case, which is already resolved.
Yes.
So do we need to discuss that first?
I don't know. I got an updated list of witnesses. Are any of those people still on? They were
never on the witness list.
Andrew Simmons, Amanda Steve, Jonathan Alleged, James Burns.
My apologies. Yes. So no, I'm not intending to call them.
Oh, never mind that. So
Okay.
none of their testimony would be relevant to this case. So that issue is resolved.
Okay. And so, are you specifically referring then, or is the thing that you want to specifically discuss here the proposed exhibits in attachment A?
Yeah.
Okay.
And Judge, I'll say, defense's motion, it makes it a little difficult for the state because it just is so generalized. And so I'm doing my best to forecast kind of what I think from the discovery. I mean, like, for example, I'm not intending to call any witnesses or put forth evidence that, 2 years ago and this is a hypothetical, 2 years ago in Massachusetts, he got into some brawl over there. I'm not intending to do that. That's not the state's plan. I'm intending solely to focus on these 2 events and some of his chatter, for lack of a better term, leading up to it on social media. That's the evidence. There'll be jail calls and letters. A lot of that stuff that the state intends when we're talking about jail calls and letters is him directly talking about what he did. So it's not even about like propensity, or it's just an admission by a party opponent. So that's where it comes into when we talk about these. I have, and I'm holding up for the record, the social media posts that were attached to my motion. There are approximately 20. They include the date that they were posted. The testimony at trial will be that they were posted on a social media application called Parler, which is roughly similar to Facebook. It's kind of an equivalent one in which you can post, or maybe Twitter. It's a social media site that is its own entity, but what it does, it allows people to post statements or written text, and then to include photographs, videos, things of that nature. And so the social media posts that I have forwarded to the court are beginning in the weeks leading up to, and then in a few weeks after and also during this time frame that we're talking about.
All right. So I assume we need to go one by 1. So attachment A, the first post is July 7th, 2020, where, and I guess for the sake of argument, do we need to address today, Mr. Westover, any foundational issues, or
Not today.
is that handled? Okay, all right. So,
Maybe later.
so I'm going to attribute these to Mr. Swinney, and okay.
We're not conceding that the state will be able to properly lay foundation, is what I'll say now.
All right. Okay, so July 7th, 2020, a post by Alan Swinney. We need help. We are planning a flag wave in Antifa Park in Portland, July 11th. We all got our Facebook accounts disabled because we had a flag wave around Chaz on the 4th of July. Please help by sharing this post. We need patriots to follow us. We need to be able to get the word out about these events. We're boots on the ground. The absolute tip of the spear as far as the right's answer to the left's violence. Help us by following us. Help us get the message out. Please echo. We got 3 Chaz terrorists arrested Saturday. Help us add to that number. Please echo. And then there is a photo. I only see a partial photo, but it just looks like someone holding a shield with some arrows in the shield.
And just so the record's clear, that image, or I would say a similar image, appears on some of the other posts. It would be the testament. It's like a crusader.
Okay.
And for the state's argument, what is important to note for the court and for understanding this evidence is that, while yes, I believe it's absolutely appropriate to go one by one through, they also have to be viewed as a whole. In other words, when one thing is said, to understand the context of them, you need to look at some of the other ones as well.
Okay.
And then fit that into the context of those dates and what he's doing, what he's saying.
Okay. Well, and it does appear that at least the next post is also from the same date. The last crusade has already started. Join us, follow me. All right, and so what inferences, Mr. Vasquez, does the state want the jury to draw from the evidence, either as a whole or this specific evidence?
You're right. I think when we look at this one and the body of them all, it is that he has an intent to engage in violence, to engage in fighting, that his specific intent is to go there, and you'll see this in some of the other texts, but this does sort of play into these two as well, to engage in what in his mind is a civil war, to engage in warfare. And this is specific to his intent when we talk about the assaults that occur, unlawfully carrying a weapon. These ones are directly connected to that. They are his motivation. They are a display of his motivation for why he's coming down, because he believes he's coming down for a fight.
Okay. And how do these inferences make a fact of consequence? I feel like you just answered that as well.
Yeah, and to be very direct, like on the July 7th, he states, "We are boots on the ground," reference to military type that's a military type statement. The absolute tip of the spear as the far right's answer to the left's violence. Again, these are all kind of war type references in which he is talking about his desire to have conflict with what he perceives as the other side, the left.
Okay. Moving on to the July 15th post. If you're down to do some real patriot shit, follow me. If you don't know who I am, search Alan Swinney in Google. We're literally fighting the militant wing of the left. We need your help. We can beat them if we work together. And that is accompanied by a photograph of several individuals. I assume Mr. Swinney is among them. This copy is not great. Holding firearms and throwing up what I have been told may or may not be either a 3% or a white power sign with their hands.
I think, again, when we look at the text here, he's saying we're literally fighting the militant wing of the left. He is directly saying what they're intending to do. It's his motivation, it's his intent. And it's part of his greater desire to gather people to come down to Portland to engage in this, what he believes is a civil war.
Okay. July 16th, we'll be having a flag wave in a town called Sandy on Friday, and possibly Saturday also, depending on how Friday goes. It's a little town outside Portland. My plan is to hit these little towns and recruit. Then we all go into Portland together. I'll get some videos and post them here. If you're in the Portland area, come on out. Flag waves are tons of fun, and there are just enough libtards around to make it even more entertaining. If you have people from Oregon following, please echo this post. If all this stuff has been pissing you off, here's your chance to do something. Even if you can't be here yourself, echoing this post will boost our numbers. This group is actively fighting the left, not figuratively. We get toe-to-toe with these people. To date, I've helped get 83 of these clowns arrested, 3 by way of the hospital and 5 off to prison. Come help us. We can do more if we work together. Mr. Vasquez, what inferences do you want the jury to draw from this evidence?
Inferences or just his plain statements, he is saying, this is the plan. I'm gathering people together to come to Portland to fight. And in all caps writes, this group is actively fighting the left. And then not in all caps says, not figuratively. So I don't know how he can be more plain in explaining his motivation than here.
Okay. July 17th. This isn't turning into a civil war. It is a civil war. How do I know? Because they are throwing explosives at me. The fighting has already started. When you get tired of losing, contact me. Upvote and echo this post. We need numbers. I'm currently camped out, parentheses, deployed in parentheses, in the National Forest outside of Portland. We move between here and Rainier National Forest outside of Seattle. When you have time, come join us. We back up local sheriffs and patrol the perimeter of each city. We need guys, we need vets, patriots, come join us. Bring a tent and bedroll. Camping in the National Forest is free and it's breathtaking here. Aside from kicking terrorists' asses, there's hiking, gold panning, kayaking. We have an old school Civil War camp set up. History is being written right now. Come be a part of it. We can beat these people easily. It's time to get started. If you can't be here but would still like to help, echo and upvote. You can recruit from anywhere. MAGA. Mr. Vasquez, I guess, why is this relevant? / what inferences do you want the jury to draw? Or
the relevance again is that this is a direct statement of his mindset, which is this is civil war, or it's not turning into civil war, it is civil war. He's saying very directly what his motivation is. He is expressing this desire to gather up people to engage in a fight. It is the motivation that brings him to Portland, and this is him explaining it.
July 22nd, the post is, this cat seriously almost got shot. He was screaming at me and started to charge me, so I reached for my weapon and he stopped. He was foaming at the mouth with rage. You will not terrorize me. Do not violate my right to free speech. Do not violate my right to peacefully assemble. Do not violate my freedom of movement. Do not violate me. It will be hazardous to your health. You won't make me afraid to walk down the sidewalk. I fought a war for this country. I'll fight another one for it.
Well, again, this is where he's saying, I fought a war, I'll fight another one. He's again announcing that his intention is to fight and explicitly saying he's ready to get into another fight. So it is in that context, particularly with the other ones, he is again very directly saying his motivation.
Okay. Now we are moving into August, which is certainly closer in time to the charged incidents. August 12th, Mr. Swinney posts, I am no longer a Proud Boy. I'll be back after I get Enrique voted out. The best thing the Proud Boys could do at this point is rid themselves of Enrique. At our flag wave Monday, about 10 of them showed up. We had more than 70 show up total though. They had 10, but we had 60 plus. Our group is much larger than theirs. They really aren't helping the cause. They are like a wrecking crew when they show up. They start talking to all the other patriots and spread dissension. We've outgrown the boys. We can do this without them here. They don't just do this with our group. They do it with any Patriot group that doesn't follow their orders. If you're a Patriot group in the Pacific PNW and need help, don't waste your time with them. I'm getting a network together here and we can move people around. Contact me. I say again, I am no longer a Proud Boy. I have zero confidence in their leadership, only the leadership. I have a ton of friends in the Proud Boys. They need a real leader in charge, though.
Your Honor, this is 3 days prior to the first incident, and it shows this continuation of his desire to gather people up to come and fight. And that's what this is about in this particular post. It is that same motivation, and it's in the days leading up, particularly taken in context with his other post about gathering people up to engage in a civil war. It shows close in time that he is still very active in that motivation and desire to do that.
Okay. August 13th, Antifa is supposedly looking for me out here in the National Forest. They're camping out here too. They are looking for me, but I already have intel that they are all camped out at government camp down the road. It's easy to find me. I'm going to give you a hint. Listen for all the gunfire and explosions. That's where I am.
Your Honor, this one would go towards the firearm that he has and had on the 22nd. It would be circumstantial evidence of that.
August 16th, so this is going to be in between the two incidents. One of the terrorists is crying to the Portland police about getting hit by a paintball. I don't know all the details, but he said they were pushing assault charges. Here's the thing. I know the lefties in charge of Portland would love to hem me up on the assault charges, but they think I'm going to turn myself into an angry mob. They are insane, LOL. Whoever's in charge of Portland can fuck all the way off. You're not going to tell me how I can defend myself. I guess you're just going to have to rely on your defunded police department to pick me up. I say again, all you lefty judges, DAs, city council, and mayors can get bent. Americans are going to be treating you like tyrants very soon. Don't tread on me. Democrats have become too extreme to govern. That's what Trump says. I believe him. I don't think I'm going to let them govern me anymore. Take the charges and stick them up your ass.
First, it is also, this one cuts in two ways. One, it's a direct admission. He's saying that, talking directly about the incident with knowledge about, with the paintballs, and this is a reference to the August 15th assault on Mr. Britton. But also, it is very much a absolute explanation of his intent and his motivation, that he is not to be bound by the laws, and that he feels that he can, in his motivation in carrying this civil war forward, that he can do what he wants. That is very much the motivation that he is bringing to the city when he comes both on the 15th and the 22nd.
Okay. On August 18th, Mr. Swinney posts hundreds of patriots will be converging on the Justice Center Justice Center this Saturday, August the 22nd. D-Day. The left has always said we were lucky, that the cops were there protecting us. You have successfully removed the cops. Now you get to deal with we, the people. You let your mouth overload your ass. What on earth will we do without the cops there protecting us? You won't want to miss this Saturday. Follow and turn on notifications. It's time to take this country back.
This one really has multiple layers of admissibility. A, it's a direct evidence that he's there on the 22nd, so identifying him. It also directly goes to his motivation, that he is wanting to fight them, and that is his motivation in going forward. It is one that it describes in no uncertain term his motivation, and really, like I said, it's that direct evidence piece.
Okay. On August 22nd, Portland, Oregon, Saturday, August 22nd, 2020, Justice Center. This is where we hold them. This is where we fight. And then there's a movie clip from the film 300. and I guess just asking out of, I mean, are you,
I'm not intending to play the clip.
okay. That was my question. Okay, so go on from there.
I would request the still frame, of course, remain in. It bolsters what is part of his post that he is trying to say, and is very much, again, both direct evidence and also evidence of his motivation, where he is saying directly, this is where we fight, and also including this battle war imagery within that.
Okay. So now we are, I guess we'll draw the line in the evidentiary sand because the next post is from August 25th. So now we are after both of the indicted events. And on August 25th, Mr. Swinney posts, I guess stuff like this is why I'm getting followers in England. I've always said when this kicks off, it's going to be global. It's going to be a global civil war between patriots and left-wing extremists. The difference between America and England, though, is that the governments of Europe have made it almost impossible for conservatives to defend themselves. The left has been set up in the United States. They've been made to believe they can beat conservatives here, even though American conservatives are the largest freestanding army in the world. The lefties here are too stupid to understand that when they successfully start the civil war here, they'll be crushed in a week. It's not going to be so easy for patriots in Europe. No worries, though. After we crush the lefties here, we'll come there and help you if I have anything to say about it. It's time to purge this world from the evil that's infested it. And this is all sort of in reference to a sign or a image. The only top part that I can see says a proud boy carries a paintball gun during a, and then there's a photo of a disembodied torso or whatever. The torso, it's only, no face, of someone holding what appears to be a paintball gun.
And so to be clear, I know that the court doesn't have been, that is a tattoo on Mr. Swinney's arm that he has.
Okay.
That is identifiable. It is also the paintball gun that we see used in the events as well. So so that, for the picture and for the reference of why that's included, that's it. That's him posting pictures or a news article of himself, but really it's the picture. This is one that is, again, it is both an admission on his part, but it is also a description of his motivation, and it's a new level where he takes it up a notch. It's not just, hey, we want to get into a civil war. It's time to purge this world from evil that infested it. So it's very much his desire, this motivational desire to engage in violence, and that is what is drawing him on the 22nd and the 15th.
Okay. On the 26th, study the picture. The blood from this peaceful protester is what they want you to see, but the reason for the blood is in his hand. I had no fewer than 15 death threats Saturday. Probably many more that I didn't hear. 3 people said they had guns and were going to kill me. Probably more that I didn't hear. You will not terrorize me. I'm going to wave flags in every square inch of this country that you say I can't. I know people want to kill me, and that's okay. None of us are getting out of here alive. I made my peace with dying for this country 30 years ago in Iraq. If they get me, 100 pissed off Americans will take my place. They won't win this, even if I'm not here to see this through. I know what the final result will be. This is America. We're Americans. We'll beat you. There is no scenario where you win this. Our victory is a mathematical certainty.
Again, Your Honor, it is that piece of combining with our post beginning back, but throughout, that he's engaged in a war. His motivation is to fight. His motivation is to engage in this, and he spells that out very clearly, the depth of his desire to engage in that.
All right. The following day, he posts one sentence: all my heroes kill terrorists.
I would say this one, the context is that in a few posts back, and I can reference it, it was August 16th. He specifically is referencing the events of August the 15th when he says one of the terrorists is crying to Portland police about getting hit by a paintball. And then he is writing all my heroes kill terrorists just approximately 11 days later.
September 3rd. Okay, so if you guys want to go to a rally to wave American flags and you don't let the left attack you, this is what you can expect from our justice system. There is a grand jury deciding today whether or not to prosecute me for hitting a guy in the eyebrow with a paintball. Please echo, this is very important. Moments like these are what determine the course of our country. Will our government let us defend ourselves? Will they make us submit to mob rule? Go through my timeline and judge me. Don't let a liberal justice system railroad me. I'm taking these chances for all of us. It's your turn to help. We're louder as a group. Make some noise. After they get me, they're coming for you. How you can help. Follow me, upvote this post, echo this post if you ...
This one contains both direct evidence where he's talking about hitting a guy in the eyebrow, which that is the approximate location where Mr. Britton was shot with the paintball. And then also, it's very much in this idea that he's taking chances. He's expressing that he is out there engaged in this behavior as his motivation.
Okay. Next is September 7th. So you want to wave flags at the Justice Center, get suited up. They won't make it easy. I was in the Army and played football for a couple of years when I got out. This is the perfect blend of the two. And there's a picture. I can't exactly see what the picture is on my copy, so I'll need the state too.
Yes, sir. So this picture, again, is a picture of Mr. Swinney as he appeared on August the 22nd. The items that he is carrying are identifiable as there's a knife, there is a pistol, which is the one that is the subject of the the menacing and the pointing the firearm at another, and is also the subject of the unlawful use of weapons. So this is both direct evidence because of the photograph included with the post, and then also the wording of the post. He is talking about they won't make it easy. I was in the Army and played football for a couple years when I got out. This is a perfect blend of the two. It is truly his mindset, motivation, talking about how he acts at these events. So it is also, I believe, critical in this analysis, Your Honor, that self-defense is the anticipation. There's been no notice filed, but my anticipation is that that will be strongly the basis of the case that the state does have the burden to disprove, and so that this certainly cuts against that, would be the state's position.
Okay. So this next page is just a photograph. Is that related back to the September 7th?
Yes, Your Honor, I
Okay.
believe it is. It is, yes, this is the photograph as a whole, just
Got it,
posted
okay.
with that one.
Okay. September 12th. They thought the 22nd was rough, ? The 26th will be tenfold. There is a video post, part 2, alt-right agitators versus BLM and Antifa is the title of the YouTube video. There is a part 1, kind of the additional caption of the video is part 1, alt-right agitators versus BLM and Antifa, with a YouTube site. Alt-right agitators clash violently in downtown Portland. Unlawful assembly declared, Portland, Oregon. Alt-right and white N, and then it goes into ellipses and has another YouTube link.
So again, this being posted by Mr. Swinney, it is an image, a still frame from a video that shows him pointing the firearm that is at issue on the 22nd, and he is directly referencing it as they thought the 22nd was rough. The 22nd will be tenfold. It is both direct evidence, but also shows the motivation that he carries forward.
Okay. September 20th, Mr. Swinney posts, lefties are losing their minds that I'm not in jail right now for this. I won't be going to jail either. The grand jury started a couple of weeks ago. It has to be over by now. No warrant by now means they dropped it most likely. If my life's in danger or the lives of innocent people around me, I'll pull a gun every time without question. These people who show up to violently shut down our right to peacefully assemble and support our political candidate are terrorists. Literal terrorists. They aren't Americans. They are seditionists, insurrectionists, domestic enemies of the Constitution. If they were in another country, we would have started drone strikes on them by now. I won't go to jail for this, and I hear the lawsuit has already been dropped. If the results of the grand jury investigation were that I was justified in pulling my weapon, then someone getting hit by a paintball would be incidental. These people are terrorists, really real terrorists. There is an image associated. It is a revolver being held by someone who's masked. I assume, Mr. Vasquez, you're going to tell me that's an image of Mr. Swinney.
Yes, from the 22nd, Your Honor.
Okay.
And again, you're in the context of determining whether someone has a right of self-defense. There is a reasonableness, and certainly this is direct evidence about whether Mr. Swinney was acting reasonable as he is expounding on what he believes his right of self-defense is. And so it is really that direct evidence when we talk about self-defense. We look at, in the shoes of that person, was he acting reasonable when he engaged in self-defense?
Okay. September 2nd. So this one, I guess, is a little...
Oh, out of sequence, my apologies.
That's okay. I mean, in Iraq, our unit destroyed over 4,000 trucks and jeeps, 220 armored personnel carriers, 48 artillery pieces, 24 tanks, and 26 jets. I wonder how many lawsuits Iraqis have pending on me. Oh yeah, I don't care about that either. We're going to take this country back from you. What you experienced Saturday at the Justice Center was just the tip of the iceberg. You're in our country. We're not in yours.
A couple of key things here, Your Honor. One is this is the date that one of the victims filed a civil lawsuit against him.
Okay.
And the other big piece is this solidifies that this is his view that he is in a war. He is actively fighting people in this country, and that is what his motivation is. I mean, he is very direct, and it's in saying that what his motivation is. We're going to take this country back from you. What you experienced Saturday at the Justice Center was just the tip of the iceberg.
All right, and last, on September 24th, Mr. Swinney posts, we have a unit large enough now that we have specialized teams inside our unit. Combat and support. 90% of people will come out here, want to be on the front line, but the front line isn't for everyone. I'm not even best suited for the front line. I'm too tall. 66% of any combat mission is support. A frontline soldier couldn't do his job without it. He can't carry enough weight in with him to properly do his job or do his job to the fullest without support. Coming to one of our rallies doesn't mean you have to directly fight the people who come to attack us. There are many ways you can help. It's no secret where we'll be. Come here and help us. You can have as much or as little action as you want. We'll help you find the job that matches your skills. Thumbs up emoji.
Again, Your Honor, it's that in here very specifically saying, directly fight. I mean, he is expressing over and over that he sees this as combat, that this is a military operation, that his motivation is to fight.
Okay. All right, so Mr. Westover, you've heard the state's arguments. So let's just go back to the start. I won't reread into the record, but the July 7th, there are the two posts regarding a flag wave on Portland, July 11th, and referring to this as boots on the ground, tip of the spear, last crusade, etc.
I can, to begin, I just want to make Mr. Vasquez basically said almost the same 2 or 3 things for every single one of these.
That's true.
One of them is it's a direct admission of being there. It's something that, irrelevant to this case, identity is not going to be something that the state is proving. They didn't articulate identity, but we're not going to come into the courtroom and say that's not Alan Swinney.
Okay.
Right? So the fact that he later said, yeah, I was there, or said something that provided an inference that, yes, I was there, that then is not relevant. So under no circumstances do I think you should find the arguments of this is direct evidence of him being there, being persuasive for, the need for the state's evidence here. There's also not going to be any. The video is plain as day. There's Alan Swinney pulling a gun, right? That's not going to be. The pulling of the gun is probably not going to be a fact that's in dispute. In terms of these first 2 posts, if he had come in and said this is relevant evidence towards Mr. Swinney's plan to go to Portland on July 11th, I'd have a tough time arguing against that. Let me just go back. I was taking notes on a separate sheet of paper at first.
I'm gonna stand up. Just ignore me. I just want to stand.
Sure. To the extent that he says this is his motive to go engage in fighting, in order for it to reach that factual inference, requires there to be some sort of inference that he is a violent person, and that is propensity. To the extent that any time Mr. Vasquez said this is the motive, that's really he's skipping the step that involves a requirement that the jury infer that Mr. Swinney is violent. To the extent as well, the state is mischaracterizing many of these. We've got, he's selectively sort of relying on quotes. Mr. Swinney talks about this, the right answer to the left's violence. He said in one that this is direct evidence of, he conceded in one of them that it was direct evidence of Mr. Swinney's belief in terms of the need to engage in self-defense. With regard, I think I referenced this, but this is not close in time to either of the incident dates, and the Last Crusade has already started. Join us and follow me. That's just too vague. We're peeling off into issues that the jury doesn't need to be distracted by. What we should be focusing on really is what happened downtown Portland on August 15th of last year and August 22nd of last year.
Okay. July 15th, the photograph with the firearm, and we're literally fighting the militant wing of the left.
One of the things that's really detrimental here is Your Honor actually sort of acknowledged it. You say that there are people that appear to be making a 3%er or a white power symbol in the photograph. That's extremely prejudicial, as well as just the.
Which one is Mr. Swinney the front and center?
He's not in that photo. This is a meme. It's not actually even the full photograph. There's words above and below that are not captured by this.
Okay, so Mr. Swinney's not in this photo at all?
Correct.
Okay.
I don't know any of those people.
He doesn't know any of the people in that photograph.
Okay.
Your Honor, if Mr. Swinney would like to take the stand and testify about that, that would be fine. But otherwise, I don't think him commenting is appropriate.
Well, I mean, do you agree that Mr. Swinney himself is not in the photo, whether or not he knows any of
I
those
do
people,
agree with that,
right?
Your Honor. And I mean, to the extent that it matters, like if there's something like that, well, while I can argue why that's relevant to this discussion, is that the plan is to gather up troops and come to fight. The motivation is to fight. That's what he's showing. These are the troops. These are the guys, right? I mean, that's the relevance of it. If the court feels like that there's on balance on a 403, that photo could also be taken out and the text could stand alone.
Okay. Next is the July 16th flag wave in a town called Sandy, possibly Saturday to, I'm assuming you're going to say if this was a plan, if the charges related to that date, this would be relevant, but.
Yeah, my 2 or 3 responses to Mr. Vasquez's 2 or 3 assertions are gonna be pretty consistent.
Okay. Okay.
But I mean, there's also just, I mean, there's prejudicial stuff in here. 3 by way of hospital. I mean, again, it's the inference there is he's a violent person. There is a necessary factual inference of violence that he himself is a violent person.
I can tell the parties, I mean, it may not, to the extent that I do want to keep going through this. I can just tell you already that I am leaning toward allowing some, not allowing some, and redacting some. I mean, it's just, I'm going to kind of go through
Maybe
these.
it would be a better use of all of our time for you to consider and say, since Mr. Vasquez has made his pitch, if there's some that, based on that pitch and based on the arguments I've made so far, those would be excluded, then we don't need to talk about those, but give you the opportunity, and then I can make any arguments necessary as to the ones that you do say that you would allow, ones that I have not already argued against, if that's.
So I think I need to spend some more, I mean, honestly, I think I need to spend some more time looking at the case law and really contemplating, I mean, you know, Skillicorn certainly is, I mean, it's relatively new still to me as a judge and to, I know both of you as parties or all of you as parties. I think, you know, in order for me to do my job correctly, I need to spend more time both with the case and with each one of these pieces of evidence. Probably sometime over the weekend, I'll email you both essentially a table of each thing and what I am purporting. And then if there's more argument on Monday or later in the week, we can, you know, I'd like to kind of get the jury picked on Monday, but I understand there may or may not be things we need to decide before we even call a jury.
Yep.
But I want to give you, Mr. Westover, the opportunity to specifically address anything else in this stack. I've kind of cut you off, which I certainly don't intend to do. But I guess I just wanted to kind of lay that out, that's where my head is right this second.
I think I was picking up on what basically you said, that you're going to allow some of these, you're going to disallow some of these, and quite frankly, some may need to be redacted to the extent that they're admissible. So the only other thing that I would want to talk about right now is we received an updated proposed exhibit list from Mr. Vasquez this morning, which includes, he plans on offering a letter that Mr. Swinney wrote to Derek Shelvin after the verdict. We'll be moving to exclude that as well, and I apologize, Mr. Vasquez, I no longer actually have that. You gave it to me at one of the release hearings.
Would you like me to send you another copy?
Would you send me another
Yes,
copy?
So, and not to be rude, but you say this, I don't know who that is. I don't know what verdict you're talking about. So
Derek Shelvin was the man who murdered George.
Oh, Derek. Okay, I thought you said Shelvin, and I was like, I don't know who that is.
Sorry.
Got it.
Yeah.
Okay, I know who that is.
Yes.
Fine. All right.
And so perhaps Mr. Vasquez can send that letter again to me and to Your Honor, so that you would have time to read its context prior to us discussing it. We'll certainly be moving to exclude that.
Okay.
There's going to be some. They're also planning on. That's the only jail letter that I understand he is currently on his list. This is sort of why I wanted an exhibit list before we started doing this.
Sure.
Because now, to the extent that Your Honor may be excluding some of the things that he wants, he goes, okay, well now what else can I go get? Right? I want him to have an idea of what his case is before you start making decisions. But that's a perfect world, and I don't get to live in a perfect world.
Mr. Vasquez, what other information is out there in the world that you might try to introduce that you haven't?
Oh, it's limitless, Your Honor. No, I seriously though, I have given the defense immense amounts of discovery in an abundance of caution. It's not that I intend that I'm going to offer everything. It's just that I don't want to then have someone say I'm not giving them the information. And so in my list, here are the categories I put out. Photographs, both for the 15th and the 22nd.
Okay, so to your knowledge, are you moving against any photographs from those?
So the photographs, in a previous hearing or previous meeting, Mr. Vasquez gave me a number of photographs. This is a picture of Jason Britton with looks like some swelling around his eye. I don't think I'm going to have a really good basis to object to that coming in. That's the injury that constitutes count 5. There are 3 photographs of Alan Swinney from the 15th. This is during the flag wave. I don't understand what the relevance of these is. If it establishes identity, once again, it's unnecessarily cumulative. It's 3 photographs. One of him standing there, another of him standing. Well, I don't mean to cut you off, Mr. Westover, but I think what might make the most sense, because I don't know what Mr. Vasquez is necessarily. He gave you a stack of photos. I don't know if all of those photos are photos that he even intends to introduce. So I think it makes more sense for the parties to confer. You're welcome to stay here in the courtroom at least until noon when it needs to get locked up, or you can use the conference, one of the antechamber conference rooms if you wish. And then at 3:30, if there's a list of still contested evidence that I can pre-rule on, to the extent I can pre-rule on it, I'm happy to do that. Some of it I think is going to come, some of this probably does depend on the extent to which a self-defense claim is pursued by Mr. Swinney. Some of it I may not be able to rule on today, and I may have to wait until I understand it in the context of the larger trial. But I just, rather than, go through and say, we won't object to this one, we will object to this one. I don't know that, I don't even know if it's an exhibit he's planning to admit, so. He did give me countless pages. I would say countless, they are counted, but...
So you feel like that's a narrowed already?
This is already narrowed.
Okay.
So this is what I understand him to be. This was on his draft exhibit list.
Okay.
So I understand that these are things that he does plan on.
Okay. So Mr. Vasquez, in your draft exhibit list, is it literally like exhibit 1 will be the picture of Jason Britton, exhibit 2 is a picture of flag waving, exhibit 3 is a picture of flag? How broken down is it?
So what I did is, I put the photograph identifier number on here, so they knew what number. I can convert that or put in parentheses like, hey, this is a descriptor of what is in the photograph, so certainly it helps with that. I was trying to, because there are, copious images and things, I'm trying to be very specific about the ones that I was offering, and I did that certainly in one. I put in parentheses, it says Meg's breast injury, because there's a picture of an injury to a breast in this case. And then the videos, I tried again to put some parentheses around there. I know that on August 22nd, that video series, there are a series of videos from that were taken off of Twitter that were posted by Mr. Sergio Olmos. I know that there were many videos, and my intention is to narrow that down considerably. And then I have tried to identify the videos elsewise, but what I've discussed with Mr. Westover, and what I plan to do is to take all of these, put them onto a thumb drive, and say, here they are, so that we're on the same sheet of music.
I would love that.
So I will work on that over the weekend. I'm happy to do that.
Okay. Okay, and then I guess what would be helpful to me then, to the extent that I am going to need to hear argument on any of the evidence that sort of that remains contested, I'd like to pre-admit what we can pre-admit, of course, and then to the extent that I need to rule any. For me, organizationally, it's very helpful to kind of have a list, and then I can write down what's coming in and what isn't. So to the extent that list then could be.
How about, may I make this suggestion, Your Honor?
Yes.
How about I put together a list. It'll have a column that says, offered, received, and then I will list them out as State's Exhibit number 1, and it'll put in parentheses what is a brief summary. I will keep it as non-advocacy related as I can.
Okay.
Right? So it'll say things like picture of eyebrow. So that will be
Okay.
So that will be and I will do that for the photographs. I'll do that as much as I can for the videos.
Okay.
And then I will create a corresponding, and my hope is my office has all the thumb drives, but thumb drives that will contain then the corresponding exhibits, and I will relabel them to correspond with the list that is provided.
Okay.
So then that everyone, the court, the defense, they can all look at the same material.
Okay.
There. So
I don't think I'm
to,
allowed to use thumb drives, but okay, I get it.
If you want, I can try to put it on a CD.
I don't think I'm allowed to use anything, honestly. Like, I don't know how, I mean, there has to be a way, but I think at least I have to have IT, like, pre-screen it to make sure there's no viruses or something, but we'll figure that out.
Certainly, we will be able to use the screens in here to look at them.
Right.
And so that way, I'll have
Yeah, so I guess maybe just don't even worry about a thumb drive for the court.
For the court. Okay.
Go ahead and, I mean, to the extent I guess you want to admit it as evidence, fine, but just know I won't be putting it into my computer. Okay.
Can I just address one more thing?
Yes, you can.
What I would love to have is, in the most current that I received, I think yesterday or maybe the day before, draft exhibit list, Mr. Vasquez talks about, indicates that he is at this point planning on offering portions of jail calls. I think that we're going to resolve this, but one of the things that I have not seen in discovery, and I don't need to go too far down that, what I have not seen is what I have seen before in other cases, which is a spreadsheet that talks about what jail calls are given when. Because he identifies, for example, a jail call December 19th, 2020 call at 11:15 to 412-403-2651. That's it gets us halfway there. I have 1, 2, 3, 4, 5 discs of jail calls, and for the record, one of them is jail calls 9/30, 2020 to 125. Here's another one at 9/30, 2020 to 121. 2021. This one is jail call 11/6, jail call 11/6, jail call 9/30 to 125, disc 2. When I load these into my computer, they just come up as track 1, track 2, track 3, track 4, track 5.
Okay.
There's no indication of what time this phone call is made, to what number it is made.
Okay.
And so if he's got those, if he wants to just specifically get those calls, those 4 that he's talking about on that jump drive, woohoo. I mean, we're going to have problems with, there's going to be issues with whether a jail call can come in at all, but...
Okay.
So, let me help out here a bit. Without, again, getting too far afield, just so the court's aware, there was a separate counsel on this before. Lots of discovery was given to them. I have no idea if they gave it all to Mr. Westover or not. I certainly tried to meet with him to make sure he did. We gave additional. That could account for some of this. We certainly tried to give lists and all of that. I will, with these specific tracks on my list, what I have done is I've identified them, and my intention is to edit them down to the relevant part.
Mm-hmm.
For example, in one of the calls, there are lots of discussions about bail and raising money for bail and all of this stuff that I don't intend to offer. And so I'm not going to put forth the whole call. My intent is to clip the part which is relevant to Mr. Swinney, where he is discussing specifically the events of either the 15th or the 22nd.
And that's fine. I mean, right, like I'm not pre-ruling, but right, what it sounds like Mr. Westover is saying is, he's got 5 discs, 3 of which are extensive date periods and times, but when he looks, it's merely tracks 1 through whatever, and so he can't just click on the track and hear what you're talking about.
Well, I understand that. It's hard for me because this is the situation. I have it on my system, and I look at it, and I'm able to.
Sure.
I believe that I have given him all of this material.
I remember, and that sometimes even just the way that the software loads things in is very different. I don't hear Mr. Westover suggesting that the state has done anything wrong here. I'm just saying, like, I understand his request that it would be very helpful for you to just pull those tracks out and give him those tracks separately.
Okay, is it okay if they are the edited ones that I intend to offer? Would that be acceptable?
I would like both. I would like the whole phone call as well as the edited. Because if we're talking, I have a rule of completion argument in case that these statements that he wants to offer, I believe are offered out of context with the remainder of that call. I want to see the whole file.
I will.
That feels reasonable.
I will put that together.
All right. Okay, so are there things we can still work out at 3:30 today, or do we think we're in pretty good shape to move into the weekend and trial prep at this point?
I've got a draft jury instruction list that I'm happy to take a look at over the noon hour and see. I've also got a memorandum in support of one special instruction that I think also I'll need to add an additional segment to that.
Okay.
I don't know if I can get that done by 3:30. So,
Are you going to be prepared to start litigating jury instructions at 3:30 today, or do you want to wait on that?
I want to wait on that, Your Honor.
Okay. To the extent you can provide stuff, I think, or the earlier the better. I can start looking at it too and preparing
We
for
can start providing our stuff as well.
what I think the arguments will be, at least, if not exactly what the arguments will be. Okay. So I think we're probably good to wrap up for today. The other thing I just want to make the parties aware of, again, assuming that you're not all living under rocks, the Portland Public School bus system is a living nightmare this year. And so it's going to be a little bit of a day-to-day. I'll be here no later than 9:30 on any given day. But if I may have to rush my kid to school if I get the 7:30 a.m. text that his particular bus line on a particular day is not operating, and that is literally the timing of the PPS texts about bus service right now.
From the state's perspective, that's absolutely fine, and if defense needs that same accommodation, or the state, I would request that.
Okay.
yeah, kids are a good reason to.
Okay. So I mean, let's shoot for 9 a.m. on Monday at least, because I want to get in the jury queue as early as possible. Now, deputies, I guess just another question for the purposes of scheduling the trial throughout the week. Is 4:45 a stop time that you would like me to try to honor every day so that we can get Mr. Swinney back, or is he being separately transported?
So if we go past 4:30, what ends up happening is he goes to MCDC for 2 or 3 hours, waits there, and then arrives at IJ pretty late.
Okay, so we'd like to try to stop at 4:30 every day then?
But if he needs to get to Inverness, we have to clear by 4:30.
And that would be our request because I imagine there are going to be times where I'm going to want to go see him
Okay.
to debrief on the day and plan for the next day.
That's fine. Then just everyone can know that, we'll start 9:15 to 9:30 every day. But if you guys are here at 9, I imagine most days we're going to have things we want to talk about without the jury here anyway. We're going to want Mr. Swinney to come up here and get settled before the jurors come in, etc. Joe and I will work out with the court. I think what we'll do, a couple of things. I think we're going to put blocking paper on the courtroom door windows to eliminate any, while I have previously stated on the record I have great faith in jurors following the jury instructions, I have less faith in them following the day-to-day instructions about where to go when. So we'll put paper over that just to ensure that people can't just peek into the courtroom and inadvertently see Mr. Swinney dressing up or down. And I think that's all I've got.
I heard a rumor a little while ago that there was sort of I don't know if I want to call it a rumor. I heard somebody saying a little while ago that there was sort of the way that a part of the courthouse is laid out, there's sort of this unforeseen, the architects didn't realize that there's like a window that in custody defendants get walked past that actually is visible from the outside. So I mean, one of the things we would constantly do at the other courthouse, and a request that we do in this case, is ask the jurors that if they're not in session or whatever, that they not be on this floor.
Well, okay, so normally I would do that. It's a little complicated by the fact that we're going to have 2 observation courtrooms on 2 other floors as well.
Yeah.
So, I mean, the great news is I have a clerk that, although we're not super experienced with jury trials in this courthouse, is super experienced. And so I know that he and I at least just kind of casually, not talking specifically about this case, but just about how we will manage trials. Now, having said that, I don't know what window you're talking
Me neither.
about.
I don't even know if it was. I was just wondering if you had heard the same thing.
I had not heard that, right? Like, so there were 2 issues. Issue 1 was when the A-B elevators were down, which they are not down anymore. But when the A-B elevators were down, if a defendant was transported on the CD elevator and brought into an A or B courtroom, it was using the same hallway that the jury rooms.
That's maybe what I was thinking about. That problem seems to be solved.
But that problem is solved.
Okay.
So then the only next issue, I think, is that window, right? If a juror is not in the back area already, where the jury rooms are, if they were to come and peek into the courtroom, and that's why we would put paper up, right?
Yeah, I appreciate that, and I think that's a good call. I feel like I've walked by courtrooms with papered outdoors.
Yeah, I think we need to all just invest in some of that contact paper that has the distorting frost thing.
And I assume also a sign that
Translucent.
says "Don't come in."
Oh yeah,
Because the lack of the ability to see through might mean some people just say, "Well, let me open the door to see."
yeah. No, so it's gonna, we will make sure the jurors are not walking in through that door ever. Like, that's for sure. And then, yes, there's gonna be lots of signage about, this, 11A is gonna be closed to the public. Again, to the extent that you, Mr. Westover, need an investigator or a colleague in the room, DAs need an investigator or colleague in the room, or an advocate in the room, the back rows will be available for that.
Okay.
But defense supporters, alleged victims, and alleged victim supporters are all.
I guess I will say, Mr. Vasquez, do you know if any of your complaining witnesses, I guess how does that relate to a complaining witness's right to be in the courtroom? Is being in an adjacent courtroom sufficient? Do you think they want to be in? I think one of them probably.
Speaking to 2 of the 3, they do not wish to be here, and I believe the 3rd had indicated not wanting to be here as well, but I'll verify.
Perfect.
All right.
Okay.
If being in an observation courtroom is something that they would object to, please let me know and we can discuss it again further on the record, and I'll make a formal ruling about that. Honestly, I say that not knowing what my ruling would be. All right, anything else for the good of the order today?
No, I have a brief sidebar with parties in Your Honor, but that's it.
Okay,